Hi everyone. You are listening to an episode of the Bur'yan podcast dedicated to decolonial reflection on international law. Our conversation on the topic is available in 2 podcast episodes. In this one, we focus on the history, key organizations and declarations of international law, as well as human rights discourse, putting special attention to the terms, conceptions, and legal entities that represent indigenous people's rights and struggles. My name is Lilia Yuldasheva. I will be moderating today, and I'm extremely pleased to introduce our guests. They are Suleiman Mamutov, expert at the United Nations Permanent Forum on Indigenous Issues and legal advisor of Amnesty International Ukraine. Selbi Durdiyeva, social legal researcher with focus on transitional justice and decolonization. And Viliuia Choinova, an environmental engineer and Sakha activist from the Republic of Sakha. Suleiman, Selbi, Viliuia, thank you for joining us today. And please, add from yourselves to this introduction.
I was born in Tashkent. I lived almost half of my life in Crimea, where my parents returned from the deportation. And for the last 16 or 17 years, I live in Kyiv. I've been living in Kyiv, studied international law, worked in humanitarian and human rights organizations, both Ukrainian and sections of international organizations here in Kyiv. And since 2022, was elected as an expert of the UN Permanent Forum on Indigenous Issues.
Very nice to meet you. It's always nice to meet somebody who was born or has some connection to Tashkent, because I have very special feelings about the place. Thank you. It's very nice to meet you. My name is Selbi. I am originally from Turkmenistan. My mom is from Kazakhstan, so I consider both countries to be home, and Central Asia in general. I've been based in the UK for the past 8 years. I'm an academic, but now I work more for a second-tier organization that on public law and public international law.
My name is Viliuia Choinova. I'm originally from Republic of Sakha. I currently reside in Finland. I have a background in environmental engineering and geoinformation sciences. Also involved in indigenous people's rights and international advocacy. I have participated in expert mechanism on the rights of indigenous peoples last summer. And also I'm going to United Nations Forum on Business and Human Rights this November, we're writing a report on the extractive industries in 3 national republics.
Let's start from the history of international law in its contemporary format. Could you please say what is essential for us to know about the history of the United Nations organization and the preceding League of Nations? What were historical events that led to its creation? And who were the key actors of this process? In particular, meaning who were included and who were excluded from participating in it? And why is it important for us to know?
When I speak about history of human rights and decolonization, I often quote one author, and I think that's one of the most important authors on the topic. It's Ariela Esha Azule, who wrote a book called Unlearning History. And there she asks a question of what kind of history, particularly the history of human rights, do we know? What kind of history of human rights everybody learning in schools and universities, etc. So what is the kind of, and she uses the word hegemonic, the dominant way to think about human rights. And the history of human rights traditionally begins with the establishment of the UN. As we know, there was a particular historical context when the UN was established. There was League of Nations first, but we are taught to think about of the UN as of starting from 1945, and also when the Declaration of Human Rights was adopted. And she says that starting, and the question of when do we start history, when do we start narrating a certain story is very important. And she said that by starting it from 1945, And of course, World War II is a very important event in world history. Of course, nobody denies that. She doesn't deny that. But starting it all from 1945 kind of erases everything that happened before that. That's one thing. The second thing is the question of actors. And this is a very important question for decolonization and decolonial thinkers, because who are the actors of international law? The primary actors of international law are states, nation states as we know them. And we have nation states since arguably Westphalian system. And it seems like we didn't know anything else, but there was something else as well. And even though there are movements and social movements and different directions and critiques of traditional way of looking at human rights at international law, and with human rights we have different subjects, including humans, arguably, including individuals, including collectives, but still the primary subjects of international law are states. Representatives and states are abstract entities, representatives of states. So how did human rights story as we know it today began, and I'm talking about institutional human rights, is that these people came, they gathered in Geneva, and they created this whole infrastructure of international law. And again, there were some things before and after, but so the question of actors is important. And the third thing will be, she says that why is it problematic to think about it from this position in terms of historical and time, and from this position in terms of actors, is that because it erases the history of colonialism. That's one thing. Another thing is what she calls imperial rights. The human rights were granted by victor states in order to forget about colonialism. So the question of colonialism was moved away. People were granted human rights conditionally. And we have this start of history of international law with the invention of institutional human rights. And last thing about the actors, she says that she does not deny the importance of human rights. And for me, that's my main belief system. But she asks the question of what kind of rights, and she divides them into sections. One section would be imperial rights. It's the institutionalized rights as we know them. And another rights are the rights that are born out of social movements. And we should not forget that the rights as we know them in these institutions are not the only rights, that there are different ways to articulate rights.
Yeah, thank you, Selbi. Actually, I was not familiar with this book of Azulay. So maybe you could explain a little bit more about this difference between imperial rights, how she calls it, and rights that derive from social movements?
That's a great question. The difference between imperial rights and the rights derived from social movements, the latter she calls disabled rights, and I don't really like this wording because of the language. But why she uses it is she says that imperial rights are taken for granted. And these are rights, again, articulated in international instruments, in international documents. And again, I don't want to say that we don't need them, but she criticized them because of the infrastructure of international law. And why she calls, and I forgot the second name, the disabled rights, but she uses another another term which I forgot, and maybe it'll come back to me. Why she calls them disabled rights is because there need to be somebody else in order to grant them rights, in order to approve those rights for them to become the rights with the capital letter. And another problem that she sees in this is that human rights become conditional. So they become conditional if you reach a certain threshold of civilization, if you reach a certain threshold, if you play by the rules of institutional rights. And she finds that quite problematic. And there are other authors, for example, Sumi Madok. She wrote a book which is called Vernacular Rights. And she writes there that we need to think about different stories of human rights. And we should not only look at the institutional, we should not only look at the UN. And she talks about the rights that are more vernacular because they come from below from in question marks, but bottom-up approaches to human rights. And she uses the term, which is, I think, common for a lot of us, it's haq from Urdu, which again means something that came from people. And with that, she also raises the question of the kind of history of resistance that we get. For example, not many people know about Haitian revolution against the French. And she quotes James, who wrote about that. So again, which events become hegemonic, become emblematic in the history of rights, and which not, which I find also very interesting.
Yeah, thank you so much. Thank you so much. And it is really a question that I didn't put, but Now I'm thinking about it, why exactly the Second World War became this turning point in the history of human rights. But I will ask Suleiman if you want to add something at this point.
I'd like to thank Selbi, because I think I fully agree that when we say that human rights appeared after World War II, then we somehow deny all the previous histories. And that when we say that, I mean, it can be said that the form of the contemporary understanding and the concept of human rights, the form was perhaps established with the creation of UN and then the adoption of the Declaration, Human Rights Declaration. But when we talk about the content and what preceded, of course, there were many developments that can go back to at least 1 or 2 centuries before the adoption of the establishment of the UN. I also think about the subjects. I fully agree that in international law, the subjects, commonly recognized subjects, are states and perhaps also international governmental organizations, because they are formed by the state. And it's also important to say that even understanding the whole concept of human rights was rather pro-colonial, pro-European, and it didn't consider the understanding, the vision, the views, and the concepts of non-European powers or non-European line of argument and thought on international law, and that the whole category of rights, which are collective rights, even though the self-determination principle and the right to self-determination were included into the founding documents and into this corpus of rights, sources of human rights in international law, like the ICCPR, for example.
ICCPR stands for International Covenant on Civil and Political Rights. It was adopted by the United Nations General Assembly in 1966 and entered into force in 1976. The Covenant elaborates further the civic and political rights and freedoms listed in the Universal Declaration of Human Rights. And blue water or salt water thesis that Suleiman mentions further is the idea that in order to be eligible for decolonization, the presence of blue water, meaning sea or ocean, between the colony and the colonizing country was needed.
Yeah, we have the self-determination right enshrined there, or mentioned there. Although it was, formulated more in a Western way and did not take into account the views of, for example, indigenous peoples who were outside of these processes, even decolonial processes. And that's what I mentioned, I think, in the Indigenous Peoples Forum in Berlin, that the problem was with this salt water or blue water thesis applied to decolonization, which framed it in a way that isolated or made an exception for indigenous peoples for the decolonial processes. And then up until, I think, 30 years after the establishment of the United Nations, the voices of indigenous peoples were not there in the system of international relations, and international law was blind on the collective rights, on the view and visions and the understanding of indigenous peoples of their place, first of all, in this system. There was no place for them. And this is a reflection of international law and human rights that stem from the pro-European understanding of what is the right. And this is in the first place, the individual rights, not the collective ones, even the rights of minorities, how Europe understands it. I mean, not all Europe, but for example, France. There's nothing about collective rights and the collective dimension for the rights of indigenous peoples. The things like free, prior, and informed consent, all of this became known in international law. In the best case scenario, I can tell like in late 80s, but in fact in 90s and like up until 2007, it was not codified other than in the Declaration on the Rights of Indigenous Peoples.
Thank you so much, Suleiman and Selbi. And let's move on to the next question. And I would ask you to say, how could you describe the role of the United Nations and international law, concepts and practice in the world right after the Second World War and in the following decades? And could you say a little bit more about what was the initial vision for its role in the world and how it turned out to work in fact?
I think that the way the UN operates and the way that international law functions is in line with how it was designed in view of those who were authors of this idea. So it's obvious for me that although it is a multilateral tool, let's say, or institution, that it relies on several key foundations and principles, one of which is the way how the UN Security Council operates, where we have 5 permanent members with a veto right. Despite the way how we see UN system today, that it may seem dysfunctional, so it was originally the way how it was designed. It was designed based on the international law principle of consent. So we do not need to expect a lot of, I have no expectations from international law that it can help us find solution to all the global challenges and issues. It probably cannot. The same way that domestic law cannot find the solution to all this, to all the challenges that we have inside the countries where we live in. I guess that this problem with the consent, it is both the problem and, it's both pros and cons for the international law system. The same way as for UN Security Council, which was designed to be the most powerful body within the UN and the most powerful body in the world, let's say, globally. But the way it was designed essentially made it the body which became one of the weakest one, because it cannot decide and it cannot find and the members cannot reach an agreement on many issues, which makes some not unilateral but unanimous efforts possible. And again, it was designed to be the very, very powerful body that can enforce decisions, that can maintain peace globally. However, due to the design, it couldn't function and operate. But at the same time, as a multilateral organization, and the UN gave an opportunity to develop a lot of concepts, including in the human rights, in the area of human rights. And I think this example with the development of the whole body of legal concepts, let's say international law concepts on the rights of indigenous people, is a really great example of evolutionary development and then adoption. And the way how, for example, the UN Declaration on the Rights of Indigenous Peoples is gradually implemented in many countries can also demonstrate that there are examples when international law can function and can work and can impact domestic legislation, at least when you live in a more or less democratic society. But I think even in the case of authoritarian regimes, even in these cases, international law can have some grade of and level of influence on shaping the understanding what is the collective right, what is the human right, and what is the right of particular groups within countries.
Thank you, Suleiman. I can build up from there. I have 3 points. One would be, and Suleiman raised that on the question of self-determination. So one of the fundamental principles of public international law and international law is that states are sovereign entities. And then there is a definition of statehood, which is given in Article 1 of Montevideo Convention of 1933, which is considered to be customary law, which gives the parameters of what is considered to be a state. So it has to have a permanent population, defined territory, government capacity to enter in international relations. So it's and there are many debates around that. It's quite state-centric. And then there is a kind of a competing principle, which is the right to self-determination. So there is if a group of people wants to live outside of that state, they have this right. And which creates certain issues and conflicts, which brings me to the second point, which is very important for decolonization, is that there is a right to decolonization in international law, which I find it to be quite beautiful. And the peoples who are fighting against, so it outlines that people have rights to fight against colonial domination. And it actually provides that colonial domination is not allowed. It's a bad thing. And there is a precedent, which would be 1960s Congo. It's often used in the examples, and it's used by International Court of Justice, saying that there are particular cases where certain characteristics of statehood could be waived in case if people are fighting for decolonization, which I find quite interesting and important. With that comes the point that decolonization in international law ends at the moment as a country obtains independence, or a group of people obtains independence or obtains statehood. So this is the cutoff. There is no other decolonization that can happen within that. And there is a very interesting book by, now I again forgot. I will come back to it.
It's a book by Milena Stereo, The Right to Self-Determination Under International Law, Self-Stance, Secession, and the Role of Great Powers,
which talks about minority, and in which case, and it looks at the example of Russia, for example, which is important for us, why minority rights, and I hate this word, but that's the title of the book. I absolutely hate that word. But why minority rights and the rights of people of self-determination in Russia and some other contexts were not given, were not protected. And she particularly looks at the example of Chechnya. And her hypothesis is that when the country is a powerful country, it's very difficult to lobby. And she outlines that the powerful country is the country that is a permanent member of UN Security Council, or a country that possesses nuclear weapons. So in that cases, it's very difficult. It would be very difficult for people within that country to exercise their right to self-determination. And the question of decolonization becomes ever more difficult. And since UN DRIP was mentioned by Suleiman, I can not jump in. So the United Nations Declaration, and it's important to know that it's a declaration. And although some elements of it represent customary law, so therefore they are binding, even the convention, the declaration. I'm just going into wishful thinking. The declaration is not a legally binding document. The sum of the obligations are still binding. It was adopted by the General Assembly in 2007, and it's very interesting to see who voted in favor and who voted against. So the 4 states that voted against, 143 states adopted for the adoption of the declaration, UN DRIP, but the 4 countries that voted against it were Australia, Canada, New Zealand, and the United States. Shocking. In some years, I think 2 years after they adopted it, and they said that they supported, etc., etc. And there were 11 abstentions. And one of the abstentions was Russia. Because whenever we do the critique of Russia and its treatment of indigenous people, everybody will say, oh, the Soviet Union recognized indigenous people, or Russia recognizes indigenous people, and which is the word recognition itself is very problematic. And what I find also very problematic in Russia's treatment of indigeneity, and the convention is, the declaration is quite interesting, because Article 7 literally says that indigenous people should not be genocided. It uses the word genocide, which, if we think about it, it's mind-blowing that you have to put something like that in the declaration. And also it talks about the right of citizenship, which some would also view it as problematic. Others would welcome for obvious reasons. What I find also quite interesting about this whole thing about recognition of indigenous people by Russia is that indigeneity is also something that is being controlled by the state, which is deeply problematic, and it's done in other countries as well. For example, in the US, you have a blood quantum, so you have to satisfy a certain, you have to prove that you believe, and the notion of kinship and belonging in indigeneity is not the same as as outlined by settler states, and for some it's deeply problematic. What's also again, about recognition and blood quantum, is that Russia recognizes from its law, I think of 2000, I can open it, around 47 plus, they call it minorly composed, and please jump in how to better translate it, indigenous people, indigenous groups, small numbered indigenous people. And if you want to be considered to belong to them, you have to fill in the form on e-gov, or how's it called, which is also, if you think about gosuslugi, to prove you have to be older than 14. There is a form you can fill in, and there are quite particular requirements. So you have to, for example, one of the requirements is that you have to reside on that territory. So what happens to people in exile? What happens to people who moved? What happens to people who are mixed? The whole question of recognition, or who counts as one, and the control of indigeneity is still under the sovereign control of the state, which is problematic. And also the last point, and it's on nation state. The notion of nation state is quite problematic for decoloniality, but and the whole idea of human rights. Hannah Arendt wrote about it. She said that, and she draws on Marx here. She was saying that, what does it mean to have human rights? And she responded in that famous essay is that it's the right to have rights. And for her, it meant that not to be stateless. So only citizens can have rights, according to Hannah Arendt. And she obviously writes from her position and from her location. And it's obviously very understandable why she was saying that. But it opens many, many questions for decolonization and indigeneity. And can we imagine different alternatives? What is also important is that there are different sovereignties. There is sovereign alterity of indigenous people, and we can learn a lot from that.
Is it possible to ask questions to each other or no? Yeah, I was just wondering about the history. How did it come to be that only 5 members have this veto right?
It seemed to me that this was a consent of global powers, that there should be a group of so-called police, or like a police institution, that could help maintain all those good things enshrined in the UN Charter. And first of all, the peace and prohibition or ban on aggression among states, or it's against aggression, first aggression, and maintaining peace. And to maintain this peace, there should be someone who can act in the role of police that could prevent further or next wars or the conflicts. So how can it be? It's the law, like this part and this structure is, I think, the norms of victors of that time of the global order. They agreed, they had a consent on this, and they almost, we can say, invited all other that time subjects of international law. You either accept, I think it's a take it or leave it approach in international law. You either accept it or you are not a part of this system.
I'll be quick, and Suleiman touched on it. These are the countries that I put it in quotation marks, were victors' powers, those who won World War II, the World War II. So Germany obviously is not in it. It was under sanctions. It was the Allies, a different bloc. For example, Japan is not in it. And it arguably it should represent every continent, but surprisingly, Africa, not a single country from out of 56, if I'm not mistaken, countries of Africa is represented, and it's the largest continent. And it has to do with World War II and who were the victorious powers at that time.
Yeah, but by the way, like in addition, why after the dissolution of USSR only Russia stayed as a permanent member, but not all of the republics? I mean, I think it's also not that obvious. I mean, it's understandable why, but still it's very problematic and creates hierarchies immediately, like from the start of creation. These 5 countries who has this veto power. Yeah, as Suleiman put it, as a police of the world, and as with a state police, it's which is also considered to be something that should prevent violence, and ended up very often as a something that actually is violent. Yeah. So I think at this point we can move to the mechanisms, the institutions within United Nations that represent indigenous people. Maybe I can put it like this. What was really universal in the Universal Declaration of Human Rights? Who were really included and considered fully human? And were there any steps towards including those who were excluded in the first place?
The Universal Human Rights Declaration has also many questions. And as far as I understand, people in the discourse around the declaration is that, now I'm talking about Human Rights Declaration, is that it also incorporated many approaches and views of colonial powers and human rights. And even the fact that decolonization, as far as I remember, doesn't appear in the text. So it says nothing about the right of colonized people to self-determination. And several states that participated in the development of this document, including Britain, France, Belgium, now no, Soviet Union, were themselves colonial powers. And it was universal in theory, but as Selbi mentioned, in practice it applied only to citizens of sovereign states, not those that still live under the rule of empires of that time. There were also clear gender and cultural blind spots. The language of the early drafts, for example, assumed a male as a Western subject as a norm. And I read it recently, by the way, that it was thanks to one of the delegates from India who included the phrase that all human beings are born free and equal. This wording replaced the earlier drafts that all men are born free and equal. And so the declaration reflected this liberal individualist philosophy of Europe, North America on human rights and collective rights, like those of indigenous peoples or colonized nations, were almost entirely absent. And even when the decolonization process started within the UN, again, as I mentioned earlier, indigenous peoples were outside of this because the Blue Water Thesis was applied to decolonization, which stated that to be eligible for decolonization, there should be some distinctive border between the center and the colonized territory, which effectively made decolonization, even talks about decolonization, impossible for indigenous peoples, not only in North America, but in the United States. But first of all, the silent beneficiary, in my view, of this principle became the Soviet Union, never wanted to talk about the colonized peoples within its territory. And up until 1982 or late 70s, the talks about indigenous peoples in the UN bodies were unsuccessful up until the special rapporteur. The name of what was the topic of his rapporteurship, I cannot recall now, but it was Jose Martinez Cobo, who was commissioned a report on the situation of indigenous peoples and what UN can do. And based on this report, by the way, became the first basis for the draft of the UN Declaration on the Rights of Indigenous Peoples. And then only in 1980s, the UN Working Group on Indigenous, not peoples, I think, even not peoples, maybe populations. Yeah, I need to recall the exact name, but I think it was not used the term people. I mean, even in 2002, when the UN Permanent Forum was established on indigenous issues, it was called on indigenous issues, not on indigenous peoples, and many delegates call on UN and UN member states to change the name. But at that time, it was also part of the consensus between states and indigenous peoples that there should be at least some organ that after UN working group can be a successor of the UN working group on indigenous peoples, and that it should collect the not only information but also act as a point of analysis and reports about relevant issues for indigenous peoples, and how those issues can be addressed, and in the form of recommendations. So we have all these reports every year on different topics that experts choose by themselves. In the end, what I'm trying to say is that for a long time, even in the UN, even with the adoption of the Declaration, the covenants on civil and political rights, on social and economic rights, the use of even the term of indigenous peoples was something that states tried to avoid and state delegations tried to be blind on. But at the same time, what's interesting, all these developments from the establishment of this UN working group and the report, and also we can include here the start of the drafting of the declaration and all the processes we should not forget, of course, within the International Labour Organization, which led to the adoption of the ILO Convention on indigenous people. All of this became possible due to, or as a result of the development of the concept of human rights, starting from the declaration in 1948. It would be impossible, I think, without this foundation to start talking about collective rights and the rights of indigenous peoples. And perhaps also of the active position of activists, of indigenous people activists in that time in Norway, in Canada, who were really, the drivers of these discussions within the United Nations. And this also became possible, as far as I understand, due to better access to education for indigenous peoples, which would be, again, impossible without all these universal concepts of what the human right is. So it's really interesting that the concept that was adopted as in a way that was not decolonial helped decolonial activists and helped indigenous peoples somehow to consistently, although slowly, advance the both recognition and understanding of what the indigenous peoples are and what their rights are and what is the collective right. What are the collective rights? I think this recognition, I think that the way the UN Declaration on the Rights of Indigenous Peoples was adopted, of course, there were many abstentions, including Ukraine, by the way. There were states, global powers that voted against it. But then we see very interesting developments when all these powers and the number of states that are against it or that try to look neutral is really diminishing with regard to the Declaration on the Rights of Indigenous Peoples. And that, in my view, maybe it starts to so there is some probably global perception that in order to be contemporary and in order to look like a modern nation, you need to adopt the declaration and start talking about its principles and start talking about recognition. That's my point. And of course, there are still many blind spots in the Asia region and partially in Africa also, because in many states there is no recognition of the indigenous peoples, and there is no recognition that all these things that we used to hear in post-Soviet countries, for example, in Russia, at some point of history in Ukraine, that we are all indigenous and how we can define who is indigenous or not. I heard this a lot from every region represented in the UN Permanent Forum, from all the 7 social cultural regions of the world. This is not just something that we get accustomed to. I heard the same in Africa. Even when you hear the statements of state delegations in the UN, many countries start with the notion like we are all indigenous to our countries, and but of course we are trying to ensure the rights of some minority groups.
Yeah, I'm just still processing what you just said, that some delegations, they claim that we are all indigenous, which makes it so problematic on so many levels. Yeah, I've reread again in Tak and Young, where they said, what's the difference, for example, of a migrant who comes to a country, can we say, or to the settler colonizer? And they wrote that migrants, they need to adapt to the whatever existing sovereign order that is there. Whereas settler colonizers, they impose the order. They claim sovereignty over the order. They say that there's the one sovereignty, the one way to exist, the one way, and that's their way. And everybody else has to erase everything that they have, all their cosmology, all their worlds, all their languages, so to adapt to the sovereign order. So like the whole of this claim, I know where you're coming from, Suleiman, with that, and I'm happy you raised that. Yes, in terms of Universal Declaration of Human Rights, yeah, it's the product of its times. And again, it's a declaration. There was a lot of critique of it. It's been widely discussed. Then there were two covenants, as Suleiman mentioned, which are binding. Universal Declaration of Human Rights is not binding, not legally binding, although some provisions of it are considered to be customary international law. And then there are what is called UN Bill of Rights. Other key core documents, conventions, like, for example, Convention Against Torture, Convention for Children's Rights, which is nearly universally ratified except of the US. So there are these other documents, and I when talking about human rights, I do like to think about it holistically and what are these documents represent. But it's important to know that even within these documents, the rights of indigenous peoples and some other rights are sidelined and marginalized, does have this human supremacy over everything, which it goes against. And again, I must have probably said I'm not an indigenous person, but I think that the question of protecting indigenous people and their lives is the question of everyone. So I think it's important to talk about that in the same way as racism is not. It might be not everyone's fault, but it should be everyone's problem. So we need to talk about that. So I'm not claiming that I know everything. I'm just using the whatever knowledges and skills I have to promote the cause. And I'm here to listen rather than to authoritatively speak. And there is no such thing as pan-indigeneity. There's like, this is indigenous. Even if we speak about within one country, every tribe has their uniqueness. And it's important to theorize from the place and location. But and anyone who claims we are pan-indigenous is also quite problematic. So, but in many indigenous cosmologies and worlds, there are rights of nature. The whole issue of supremacy of human is quite problematic. Maybe that's why it brought us where it brought us, because we've been overly consuming and overly producing. And there is a book called The Red Deal, where it talks about climate change and that we need to learn a lot from indigenous peoples because they know how to survive in extreme conditions. They know how to relate to nature in a different way that is not extractive. And all of this is obviously omitted in the institutionalized human rights. What is also important is that indigeneity should not be reduced to culture only. That it should be political as well. It's not only cultural. It's something that the USSR was doing, something that Russia is still doing. It also should allow for opportunities and options for re-indigenization. So it's not a fixed category that, okay, that's it. That people who, for example, left, they should have a chance to maybe relearn their language, relearn what was lost. And in this way, indigeneity should not be reduced to the past. It's not the question of past, it's also the question of future. So how do we imagine a different future or futures as well? What is also interesting, because Suleiman was mentioning about collective rights, we should also not forget that there are regional instruments of human rights. What came to my mind immediately was the African and Human and People's Rights Charter. And even here, even in the name, we see that it's not only about human, it's also about people's rights, and it has quite regional specific. Also, Inter-American Convention of Human Rights. It's been one of the most, I will put it in quotation marks, but progressive instruments, especially when it comes to, for example, reparations. And it also kind of escapes the debates. And often when we speak about human rights, people have this obsession with the Universal Declaration of Human Rights, forgetting that it has human rights is not something unilateral. It has so many different things in it. It has UN instruments, which are quite many. We can talk about them, has regional instruments, plus there are human rights outside of this institutional human rights. There are human rights as articulated by particular groups of people, which I think would be quite interesting to learn more about.
You were listening to the Bur'yan podcast, produced by Bida Media. To hear the continuation of our conversation, check out the next episode. We'll talk more about what our guests, Suleiman Mamutov, Selbi Durdiyeva, and Viliuia Choinova, experiences are in the fields of studying and working in international law and human rights organizations and advocating for indigenous people's rights. Moderating this episode was me, Lilia Yuldasheva. Thanks for listening and stay with us.